Good day, everyone. We're excited to have you join Registrar Corp for Avoiding FDA Refusals, How to Resolve Detentions and Overcome Import Alerts. We'll be discussing how and why FDA detains shipments entering the U.S. and how you can get your goods released. We'll also be speaking about the FDA system of import alerts, where certain shipments are targeted for detention without any physical examination or inspection by FDA, and how a company can overcome one. Thank you for your participation today, and we hope that you find it helpful. I'm Anna Benavente, Registrar Corp's Director of Product Labeling and Ingredient Review, who will be contributing to this webinar. I've been with Registrar Corp since 2009 and have over 15 years of experience in analytical research focused on regulatory affairs. Since joining Registrar Corp, our label review team has reviewed over 13,000 products for FDA compliance. My areas of expertise include import alerts and detention assistance, product formulation requirements and labeling for cosmetics, OTC drugs, food, supplements, and medical devices. I'm joined by Andrea Yon, our Senior Regulatory Specialist with a focus on import alerts. Andrea has a bachelor's and master's degree in chemistry and has specialized in FDA regulatory compliance for over 5 years. She brings a strong background in regulatory analysis, helping companies navigate complex FDA requirements. Andrea has supported more than 30 firms navigate removal from detention without physical examination. She has conducted over 400 detailed product and label reviews across a wide range of regulated categories. Her areas of expertise include import alerts, detention assistance, product formulation requirements, and labeling for cosmetic, OTC drugs, food, supplements, and medical devices. We're excited to be here today to share insights and practical guidance on navigating FDA detentions and import alerts to help you strengthen your regulatory readiness. So these are the topics that we'll be covering today. We'll begin with a quick overview of how the U.S. import process works, with an emphasis on where and how FDA exerts its jurisdiction on the products it regulates. We'll describe how it investigates and can detain products found to be in violation of FDA rules and regulations. Our next section will be a deep dive into the detention process and how you can, in certain cases, get products released and avoid import refusals. We'll look at some real-world cases to illustrate what this looks like on the ground. I'll then hand it over to Andrea to go over detention without physical examination, also referred to as import alerts, and how they are used by FDA to automatically detain certain products with a history of violations or ones that FDA suspects will present a hazard to U.S. consumers. She'll discuss the protocols for getting these products released and how to petition FDA for removal of your company and product from import alert. We'll have some examples of how this may be done and then present to you our services to help your company navigate these matters and achieve compliance and trouble-free exportation to the U.S. For those of you who may be unfamiliar with Registrar Corp, we are a firm that specializes in FDA regulatory compliance, with over 30,000 clients in over 190 countries. We have 20 offices worldwide to assist our clients in their time zones and languages. We are very proud to have a high level of satisfaction from our customers in over 20 years of service to companies in the food, supplement, cosmetic, drug, and device industries. We offer 27 different services and software options to help your firm achieve compliance with your information protected by a system that is ISO 27001 certified and backed by a team of regulatory experts totaling over 460 years of experience. Our product labeling and ingredient review and import alert team of experienced professionals hold multiple advanced degrees in the areas of biology, chemistry, quality management, botany, and cosmetic sciences. As I mentioned, we've reviewed over 13,000 products for compliance, and we take enormous pride in ensuring that our clients meet FDA's requirements. So let's start with an introduction to the U.S. import process. How does it work, and what is the process when FDA finds a non-compliant product? We'll begin with a few definitions for the players in the process. We're all on the same board. U.S. Customs and Border Protection, called CBP, is the federal agency that has jurisdiction over all commercial entries coming into the United States. Formal shipments will come in under a customs bond. The Food and Drug Administration has inspectors and compliance officers assigned to the individual ports, and they will have jurisdiction over any commercial entries containing products regulated by FDA. All commercial entries will be filed by a customs broker who has been licensed by CBP to perform this duty. Typically, they are hired by the U.S. importer. On the industry side, generally speaking, every shipment will involve the manufacturer and possibly an additional entity acting as an exporter, of course. The importer of record in the United States is the entity that holds the customs bond and is registered with U.S. Customs. For import matters, CBP considers them to have legal rights to the shipment, which has ramifications we'll discuss when products are detained. At times, there may be a different entity acting as consignee who has legal rights to the shipment, but does not actually hold the customs bond. It's important to understand that all FDA-regulated imported products must meet the same standards as domestic products and are subject to FDA review. FDA determines admissibility and may refuse entry to products that violate or appear to violate FDA laws. When an exporter ships products to the U.S. importer, an entry is filed by the customs broker with CBP. CBP reviews the entry, usually electronically, and will alert FDA if FDA-regulated products are present. FDA will review the entry using a system they call PREDICT, which stands for Predictive Risk-Based Evaluation for Dynamic Import Compliance Targeting, which assesses the risk level of the products in the shipment. FDA will then select certain shipments based on this review for inspection or sampling if conditions warranted. Also, if the product is subject to an import alert, this is when it will be flagged for detention without any physical examination. When FDA staff assess admissibility of a shipment, they use tools like PREDICT and internal databases to determine if the product should be held for inspection or sampling. They may also use information from other federal agencies, foreign governments, or public sources. They will consider a number of factors. Chief among them is the compliance history of the manufacturer. Manufacturers with a history of sending non-compliant products, also called violative, will have a much greater chance of being held for inspection. Same with manufacturers, importers, and exporters who have had previous refusals, recalls, failed inspections, or warning letters issued to them. Also, products with an inherently higher risk, such as sterile injectable drugs, will be more likely to be inspected than a garden variety cosmetic, as well as those products that are from a category of products that have historically presented issues upon entry, such as seafood. Seafood tends to have a much higher risk of contamination or decomposition and will be inspected certainly before FDA inspects a load of crackers, for example. Now, certain countries present a higher risk level, sometimes generally, but also sometimes situationally. FDA can consider geopolitical events and public health crises. For example, after the Fukushima Daiichi nuclear accident in Japan in 2011, FDA stopped shipments of certain food products from that area for a period of time. And like many instances in life, improper paperwork can complicate things unnecessarily. If the entry paperwork is inaccurate or not complete, this can trigger an entry for manual review, which often results in delays. So what actually happens when a shipment is flagged? If FDA decides that they want to inspect a shipment and or take a sample, they will issue a hold. The importer or consignee must not distribute the product or risk violating the customs bond. If the bond is violated, the importer may have to pay a penalty 3 times the value of the shipment. An FDA inspector will perform a physical examination and may take a sample of the product with them for additional inspection or testing. Depending on the concern, they may subject it to increased scrutiny or send it to a lab for analysis. For example, if they suspect illegal or undeclared colors, or if they have concerns about histamines in fish, all sorts of reasons. Now, if they find no violations, then they will release the product and compensate the importer for the value of the sample. If they do find violations, they will detain the product. Now, if you do find yourself in the situation where your product is detained, there are strategies that you can use to secure release of your product in some cases. Not all detained shipments can be saved, but quite a few can. Sometimes a manufacturer has forgotten to file or renew their registration with FDA. That can be fixed while the product is being detained. Once filed, FDA will usually release the product. Same with the prior notice that was inadvertently not filed properly with FDA. This is the advance notice that needs to be sent when the shipment is still in transit. Now, sometimes FDA will allow prior notice to be filed and then can release the shipment. Also, sometimes FDA will even allow for FCE SID filings that are required for shelf-stable canned and bottled goods to be filed while the goods are being detained. Now, improper labeling is a common cause for detentions, and FDA will permit you to file a petition to request permission to recondition by relabeling the products. Similarly, there may be cases where a product is adulterated, for example, maybe insect infestation, but it can be successfully reconditioned by fumigation or other means. There's also the situation where a product is actually compliant and FDA is mistaken, thinking that it's violative. In these cases, you may submit what is called testimony of admissibility to prove that the goods are compliant. In other cases where FDA suspects adulteration, you may be able to get the product tested by an independent laboratory to prove that the products are not in violation. Some shipments, however, probably cannot be saved. If FDA takes a sample and either visually or by lab testing finds filth or decomposition, it's very difficult to overcome those lab results to prove that they should let the goods be released. Also, if a product is deemed an unapproved drug, or if it's something like aquacultured seafood that has an animal drug residue, then there's really no way to save it. Illegal color additives and residues of illegal pesticides also can't be rectified, as there's usually no way to remove them from the product successfully. Now, Andrea will be talking about import alerts in a few minutes, and we'll go into greater detail. But know that some products stopped under import alert can be saved, but others cannot. So, for example, if you are on an import alert for a refused or failed inspection, or if you have inadequate process controls for your FCE SID products, or if you cannot demonstrate proper good manufacturing practices, those usually cannot be resolved while the product is detained in port. So how will you know what is happening to your shipment? Well, FDA will issue what are called notices of action, or NOAA, for each action taken. So when they hold a product, NOAA issued. When they sample a product, NOAA issued. When they detain a product, NOAA issued. However, NOAAs are sent to the importer and consignee and the customs broker. Exporters and manufacturers do not receive NOAAs directly and must rely on the importer to provide them. So strong communication between exporters and importers is critical to ensure timely responses. If detained, NOAAs will give the exact violations found, a reference to the applicable part of the FD&C Act. Also, they do not recognize the exporter or the manufacturer having legal rights to the shipment in this context. So FDA will only accept communications from the importer or consignee or the customs broker, or potentially an agent designated by the importer. So it's very important to know that the NOAA provides a respond by date, which the importer must respond to the charges. And a failure to respond by that deadline can result in a refusal of the entry. Even if the products are actually compliant, you've missed your chance to prove it. So again, these are all factors that you need to keep in mind should you discover that your products are being detained. And Again, just to reiterate, communication with the importer is probably the most important thing, just so that you can have access to this information from FDA. So this is an example of an actual notice of action. You can see the main parts on these screenshots. It'll identify the consignee, importer, and the customs broker or filer. It gives a breakdown of the lines in the shipment and then provides the charges. In this case, you can see misbranding for labeling issues. And it also gives the FDA compliance officer in charge of detention. This is with whom you would communicate to try and secure a release of the product. You can also see the respond by date in bold on that second page in the middle that you absolutely must meet in order to avoid an automatic refusal for the shipment. Now, this is a NOAA for a product that was detained after the inspection of the goods when an FDA investigator found the labeling violations. And this is an example of a NOAA when the product was stopped under an import alert. It has all of the same information, including a respond by date, which means that you can try to challenge the detention and prove that the goods are compliant. Now, as you see on that second page in the middle, it's clearly marked as detention without physical examination. And this is how you know what the situation is. So what is the pathway for following, depending on the situation? Well, if your product is compliant, you can prove it in a number of ways. Testimony of admissibility is a submission that attests that the products are not in violation, usually with some supporting documentation. So for example, we've helped clients who had dietary supplements stopped based on the claims in the labeling. The officers in port detained them saying that they were drug claims. But we proved that FDA guidance documents and other publications verified that the claims were appropriate for supplements. So FDA had to release the shipments. Another example is with adulteration charges, where FDA suspects adulteration like illegal ingredients, but does not have definitive proof. You may hire an independent laboratory to test the product in port and submit their results as proof of compliance. Now, if your product is actually in violation, but you think you can fix it, then you should try to save it. If it's a matter of a simple filing, like a food facility registration, complete it before the respond by date and inform the FDA officer. If the problem is more complex, the route to take is with a 766 request to recondition the product often. There's a Form 766 to complete and submit with supporting documentation to demonstrate how it will bring the products into compliance. So for example, if you plan to cover old labels with compliant ones, or if you plan to treat the products to get rid of pests, this is how you can request permission. If FDA grants it, then the importer will be allowed to recondition the products. However, you must let FDA inspect before you distribute. They must confirm that the goods are now in compliance, and you must wait for them to release the goods. If bringing the goods into compliance is not feasible, for example, if it's too costly, it may be in your best interest to request voluntary refusal. You will have to re-export or destroy the products under supervision by Customs and FDA. Sometimes FDA can take a while to formally refuse a product, even past the respond by date. They can linger. So to speed up the process, you can request it formally to get that process underway. And finally, if there is a failure to act on the part of the importer, then it will be refused automatically once the respond by date passes. To avoid this, you will want to track your shipments carefully and communicate with the importers in the event that any have been stopped. So how does this manifest in the real world? Andrea and I can tell you that each detention presents its own unique sets of challenges, but we'll try to give you some good examples of how we resolved, or could not resolve, some of our clients' detentions. I'll start with some examples that involved products not on import alert, stopped and detained after inspection and sampling. So our first example involved canned green beans and kidney beans that had been stopped for misbranding. They lacked proper net quantity statement and did not have our mandatory nutrition facts chart on the label. The importer reached out to us, and we quickly determined that we could request permission to relabel, since that was all that was wrong with the products. Now, the importer had no idea how to develop compliant labels, so he used our Label Comply service, through which we developed compliant labels for both products, including fixing the issues that FDA had not noticed, but could have been an issue if left unaddressed. We then drafted the 766 request with the completed form, and then copies of the original and revised labels, also an explanation of how precisely the revised labels addressed each violation, including the regulatory citations, so that FDA would know that experts had been involved. And to be sure that FDA would know that the end result was going to be a compliant label, we included before and after pictures to show what the results of reconditioning would look like. We met the respond by date and got it approved. So the importer was now allowed to relabel, and then we helped arrange for the reinspection after that was complete, so the goods would be released. It's a very involved and complex process, particularly drafting the 766 form. You want to be sure that you address any possible reason that FDA could deny the petition. Sometimes if they deny it, they will let you resubmit another, but not always. So it's best to get it right the first time. Another scenario that can be common is when a product has both misbranding and adulteration charges. So it is important to understand that both must be dealt with. In this case, it was a red candy that FDA suspected of having illegal colors, and then also cited the label for not declaring them in the ingredients list. The importer reached out to Registrar Corp to assist. We communicated with the manufacturer and determined that carmine, which is a legal color, was present, and we got formulation documentation to support this. We also directed them to a lab that was familiar with the FDA protocols for testing products that are being detained and submitting the results in the proper way. The lab tested to prove that carmine was the only color and that the colors FDA suspected were not present. While the testing was being conducted, we created compliant labels that included the proper declaration for carmine color and submitted the 766. Testing can take a while, so we arranged for an extension which FDA granted. They usually will grant at least one extension if you're pursuing a proper path to developing a 766, but you have to be sure to ask for it before the respond by date passes. Our 766 petition was approved, and the lab results showed no illegal colors. So after the products were relabeled successfully, FDA released the shipment. And with that, I'm going to hand it over to Andrea to talk about import alerts and how they are used by FDA and how companies that are on them can successfully overcome them.
Wonderful. Thank you, Anna, for that comprehensive look at the U.S. import process and also at FDA detentions. So now I'll dive into import alerts, which, as you know, is sometimes referred to as DWPE, which can also be known as detention without physical examination. So we'll walk through what import alerts actually entail, how a company might end up on one, and most importantly, what steps can be taken to navigate and resolve them. So whether you're dealing with a current alert or you're looking to prevent future issues, understanding this process, it's really key to maintaining smooth import operations and also to ensuring regulatory compliance. So let's start by taking a closer look at the basis for FDA's import alerts. Import alerts, these are issued to notify all U.S. entry ports that certain products from specific regions or manufacturers may be in violation of FDA's laws and regulations. So these alerts are triggered typically when the FDA identifies a pattern of violations, and this suggests to them that future shipments from the same source may also be non-compliant. A firm or a product can be placed on an import alert for many different reasons. Some of these can include a history of compliance violations. This could also include results from product sampling. It's important to know that even just a single violative sample here, it can be enough to result in an import alert. Additionally, if there's evidence of adulteration, and this could include issues such as salmonella, pesticide residues, illegal color additives, or this could include findings from an establishment inspection. So ultimately, in short, any evidence that future shipments might be violative of those FDA laws and regulations, this could lead to DWPE. And it's truly important to understand that a company does not need multiple violations to be listed. Sometimes just one serious issue, especially if it does pose a potential risk to US consumers, this is enough. Also, there's many different types of import alerts, and they address a very wide range of regulatory concerns. So these can range all the way from microbiological contamination to labeling violations. And on the next slide, we'll take a closer look at some examples of the types of import alerts that are currently in effect. And as of now, there are approximately 153 active import alerts, and all of them are publicly accessible on the FDA's website. So to give you a better sense of how broad the scope of import alerts can be, let's take a look at a few examples. As you can see, they're organized by country, by product, and also by type of violation. So by country, we can see import alerts such as wafers from India, certain types of cheeses from France, and dried peppers from Mexico. By specific product type, there's import alerts for specific seafood products, for puffer fish, and also tamarind. And then by charge or violation type, some of these alerts can include salmonella, unapproved new drugs, and misbranded food products. Now that we've covered the basis of import alerts, let's take a closer look at the key components that make up an individual alert. So each import alert begins with the reason for the alert, which outlines the specific issues that triggered it. With over 150 active import alerts, these reasons do vary widely, and they can range from safety concerns, such as adulteration and contamination, to misbranding violations, which could include, an example would be inappropriate labeling. Next is the guidance for field staff, and this provides FDA personnel with instructions for how to handle shipments and to evaluate requests for removal from DWPE. So this guidance could include specific testing protocols, or it could include documentation that has specific requirements such as food safety plans, SID filings, and things of that nature. The alert will also include a product description, which will officially identify the types of products in question, and along with the relevant charges. And the charges are the regulatory basis for why the goods might be considered violative and therefore be subject to DWPE. The alert will also list the countries of origin, and this is typically in alphabetical order. And then finally, it will include one of three types of lists: red, yellow, or green, but most commonly either a red list or a green list. So a red list will identify firms and products that are subject to automatic detention. And those firms that are subject to a red list are generally working to be removed from that red list by demonstrating compliance. On the contrary, a green list includes firms that have successfully demonstrated compliance, and they're therefore excluded from DWPE. So for firms that are affected by these types of import alerts, being added to the green list is ultimately the goal that you're trying to achieve. And the yellow list, this is much less common, and it flags firms, products, or countries, and these are under intensified FDA surveillance due to potential violations. So with that foundation in place of what's included on an individual import alert, let's now dive into the DWPE process itself and explore how firms can work towards removal from DWPE. So when an import alert is triggered, it instructs FDA compliance officers to detain certain products without conducting a physical examination. This means that products that are subject to DWPE are automatically detained upon their arrival into the US, and no inspection by an FDA officer is required. As Anna mentioned earlier, FDA will then issue a notice of action, and that will inform that the goods have been detained, and it will also specify if that detention has been triggered due to an import alert. And then once the goods are detained, the importer, the consignee, the customs broker, or a designated agent can respond. And as we discussed earlier, this can either be done by submitting testimony of admissibility if the goods are already compliant. This could also be done by submitting a reconditioning proposal, and this would be if the goods are violative, but they can be brought into compliance. For example, as we've discussed in the examples, this could be correcting inappropriate labeling by use of compliant sticker labels. The other pathway is voluntary refusal. For example, if it is too costly to recondition the goods or if they cannot be brought into compliance. And it's very important to highlight again here, as Anna noted, that some shipments just cannot be salvaged. For instance, if a firm is on an import alert due to a refused or a failed inspection. Another example could be if a product is prepared, packed, or held under insanitary conditions, or if there's GMP issues. These type of issues, they can't be resolved while the goods are in port. So in cases such as these, it's very important to understand if this applies to you, because a firm would be needed to be removed from DWPE first before shipping future goods. So if you have a clear understanding of which category that your situation falls under, it can really help streamline the DWPE process and also potentially help you avoid those unnecessary refusals. And as long as an import alert remains active and a firm is subject to DWPE under that import alert, the goods will be continued to be detained each time they're exported to the US. So this cycle will persist over and over again until a firm successfully petitions to FDA to be removed from DWPE. So now let's dive into what a petition to FDA for removal from DWPE entails. To be removed from DWPE, a firm has to submit a petition to FDA's Division of Import Operations, also known as DIO, and this petition should demonstrate to FDA that there's evidence of sustained compliance. So the petition should include an explanation of the initial violation, and this should include a root cause analysis, which will investigate and identify why that noncompliance occurred in the first place. Then the corrective and preventive actions taken to resolve the issue and also to prevent future occurrences should be described. Supporting documentation is essential to validate these corrective and preventive actions. So this will vary widely depending on the specific type of import alert and also the unique circumstances of a firm or the product itself. This could include revised labeling, food safety plans, training records, sampling plans, things of that nature. So it truly depends on the specific circumstances. And also in many cases, FDA also expects evidence of compliance over time. And this is demonstrated to them by including in the petition a series of multiple non-violative shipments. So to be eligible for inclusion in the petition, these shipments, they need to be stopped under the applicable import alert, they need to be proven compliant, and then FDA needs to subsequently release them. And this process in and of itself would be repeated over and over again until enough compliant shipments are documented to support the petition. And as we alluded to earlier, it is important to note that some import alerts do not accept shipment evidence. As we've discussed, some issues, they just cannot be fixed in port. For instance, those a product that's prepared, packed, or held under insanitary conditions. So in these cases, a firm must first resolve the violative issue and be removed from the import alert before they can resume shipments. Otherwise, those products, they can be subject to refusal. Once the firm has completed its root cause analysis, implemented those corrective and preventive actions, and if applicable, collected a sufficient number of cleared shipments, the petition can then be compiled and submitted to FDA's DIO. Once it's submitted, the petition enters a review queue and it's evaluated in the order it was received. And during that review process, DIO may reach out to request additional documentation, and this could be to clarify or support information in the petition that was submitted. And in many cases, the petition is also routed to the relevant FDA center. An example would be the Human Foods Program for food-related import alerts. And this can be done for further evaluation by the subject matter experts. And obviously, this would depend on the nature of the product or the violation and the type of import alert in question. So I'm sure, as you've gathered, it is very important to understand that this is a lengthy process. Case in point, DIO's reviews, we found they do take several months, and there is no way to expedite their timeline. Another key point to keep in mind is that simply having cleared shipments does not guarantee removal from DWPE. For a petition to be successful, FDA needs to be absolutely convinced that the underlying issue has been fully resolved and the issue will not occur thereafter because those corrective and preventive actions are adequate. Essentially, the agency needs to be fully confident that the products in question are safe for U.S. consumers. And if they do have any doubts about the safety of a product, they will not hesitate to deny a petition. Because of the time involved, it is critical to ensure that all aspects of compliance that are addressed thoroughly and there's no missing information or gaps in that petition before it's submitted to DIO. And this really does help avoid delays, and it can increase the likelihood of a successful outcome. So when a petition is submitted to DIO, if it's approved, FDA will issue an approval letter to the submitter, and they'll notify all of the district offices of the change in status. From that point forward, the entries will no longer be subject to DWPE, although they may still be subject to routine inspections, just like any other FDA regulated shipment would be. And if the petition is denied, FDA will issue a denial letter, and it will explain their reason for their decision. There is no penalty for a denied petition, and firms are allowed to submit new petitions once those identified issues by FDA have been corrected. And as Anna mentioned earlier, detentions absolutely come with their own sets of unique challenges, and import alerts, as you can imagine, they're no exception to this. So now I'll walk you through a few real-world DWPE examples and highlight some of the key takeaways. So first, we'll look at a real-world example involving mole paste, in which the firm was placed on import alert 4502 for undeclared artificial colors. In addition to the color violations, the firm's product labeling, specifically the nutrition facts panel, it was also not compliant with FDA's regulations. So following the firm's placement on the import alert, they did decide to reformulate the product to completely remove the artificial colors. So when the firm resumed shipping for the purposes of collecting shipments for their petition, the goods were inevitably automatically detained when they arrived in the US under that import alert. And at that point, the firm needed to demonstrate compliance in multiple areas. So this not only includes securing third-party lab testing to address the color issue to confirm that the products no longer contained the artificial colors, but this also included proposing a reconditioning plan to correct the labeling issues, and this was done by use of compliant sticker labels. So although the reconditioning proposal was submitted on time and the labeling was addressed, the firm did fail to obtain appropriate third-party lab testing, and they didn't do this in time to submit this by FDA's respond by date, and as a result of this, the shipment ultimately was refused. So this case really illustrates how complex DWPE situations can be. There's many different factors involved, and it's especially important to note that when a product's detained, FDA can evaluate all aspects of compliance, not just the specific issue that is listed on the import alert. It's all potentially subject to regulatory enforcement. And it also really underscores the importance of understanding FDA's requirements early on in the process and seeking expert guidance, which can help avoid those costly delays and refusals, which are costly as well. Now let's take a look at a case involving cherries, which were detained under Import Alert 9908 due to pesticide residues. So the firm traced the pesticide issue back to pesticide drift from a neighboring farm who was using an unapproved chemical. The firm conducted their root cause analysis, they implemented the corrective and preventive actions, and they began shipping to collect the shipments for inclusion in the petition. However, when they came to Registrar Corp for assistance, they were unaware that those shipments needed to be detained and subsequently released under the import alert to qualify as evidence and therefore be able to be included in the petition. And additionally, their shipments were clustered very closely together, so they didn't adequately demonstrate to FDA compliance over time. Fortunately, we were able to quickly identify these potential pitfalls, and we advised the firm early in the process. So this allowed them, they adjusted their shipping strategy, and their future shipments were, we helped ensure that they were eligible and they were also properly spaced out. And ultimately, the firm collected a sufficient number of cleared shipments. We submitted the petition to FDA on their behalf, and they were successfully removed from the red list of 9908. So this case really highlights the value of expert guidance in navigating DWPE. Identifying those pitfalls really early on can help streamline what's already a very lengthy process, and it can really help improve the chances of a successful outcome. So we hope the information we've shared today has given you a clear overview of FDA detentions and import alerts. If these processes do still feel overwhelming and you prefer expert guidance, Registrar Corp is here to help you. Our team offers a wide range of solutions designed to support your compliance needs. We have many solutions to help make sure that you are meeting FDA's requirements, and we do offer varying levels of assistance to meet exactly what you might need. So as far as detention is concerned, as far as we've discussed, they can be very complex and challenging to navigate, and each case presents its own unique set of hurdles, and having the right support here can truly make all the difference. And that's where our detention assistance service comes in. So under this assistance, we offer you personalized one-on-one support from a regulatory specialist who deeply understands the intricacies of FDA's requirements and also their detention procedures. Our service will also include expert guidance with reconditioning plans to help your shipment be sure that it is brought into compliance with FDA standards. We'll also assist with the preparation of all required documentation and also all FDA forms that are required, and we'll ensure that everything is accurate and it's submitted on time. And throughout the entire process, we will maintain ongoing communication with FDA and will act as your liaison to keep your case moving forward. And you'll receive clear and timely updates on FDA's determination, so you're never left in the dark about your shipment status. With this assistance, our goal is really to simplify the detention process for you and help you resolve those issues efficiently, minimizing the delays and thus protecting your business. Now that brings us to our import alert assistance. And as I'm sure you've gathered from what we've discussed, navigating DWPE in the petition process is very time intensive and it's very complex. And that's why we do offer comprehensive support to help you through every step. So with our import alert service, you'll receive personalized guidance from a regulatory specialist to ensure that you understand the requirements and the strategies that are needed for a successful petition. We'll provide support to you through your corrective actions, and they'll also support including assistance with those post-corrective action detentions. Our team will help compile all of the required documentation for the petition, and will conduct a thorough review and also the enhancement of the supporting materials to strengthen your case. We will handle the drafting and the writing of the petition and also the submission of the petition to FDA on your behalf. Then throughout the review process, we maintain ongoing correspondence with FDA to keep your petition on track, and you'll receive clear communication of FDA's final determination so that you are always informed. It's truly important to note that this is a very time-intensive process, so the sooner you begin, the sooner you can work towards removal from DWPE and resume your normal import operations. Additionally, Registrar Corp has many other ways that we can help you as you export your goods. We offer a full range of compliance services, all of which are fixed fee, and we can assist you with many FDA requirements, such as food facility registration and U.S. agent services, prior notice requirements, compliant labeling, low acid and canned food requirements, food safety plans, and services to meet the requirements of foreign supplier verification program. If you're unsure whether you may need detention or import alert assistance, we are happy to help you. You can send your notice of action or the import alert status of your firm to us for a free assessment. Our team of regulatory advisors will provide you with our comments and can give you further information regarding our detention and import alert services as they might be applicable to you. We truly look forward to assisting you with the smooth and successful exportation of your products. And with that, we will open up our webinar for any questions that you might have. Please feel free at this time, if you haven't already, to add them to the Q&A box at the top of your screen, and we'll get to as many questions as possible as we can.
Great. Thank you so much, Andrea, for all of that information. I know a lot of companies that are with us today are probably facing import alerts, and so it's truly helpful to get a clear understanding how you end up on an import alert, what can be done to resolve it. And I'm looking at our Q&A section, and I think we have a lot of questions for you dealing with how to manage DWPE. And so without any further ado, let me go ahead and get started here. So first question, can FDA issue a DWPE even if the manufacturer is not on the red list?
If a manufacturer is not on a red list, then it wouldn't necessarily cause the product to be detained without physical examination. It wouldn't necessarily be flagged to be automatically detained. That it is possible, though, that if the goods being shipped, if perhaps there is a history of refused shipments or things like that, Anna spoke to the predict score, there is a possibility that there could be an increased likelihood for a detention. So although, a particular manufacturer, if they're not on an import alert and they're not being flagged to be stopped automatically, if there is a history of compliance, it could increase the likelihood that a shipment could potentially be stopped and therefore detained and subject to regulatory enforcement.
Okay, great. Thank you. Next question. Is it possible to have a list of colors that are not approved? Okay, I can take this one. So unfortunately, there's no prohibited color list. The way that color additives are regulated by FDA is that they have to be approved for their specific use. So in essence, what you need to do is research whether or not your colors have actually been approved for the exact product that you're adding them to. And so if you need assistance with this, actually Registrar Corp has services that can research your product ingredients, your product colors, and determine whether or not there are any problems or any illegal colors that are in there. Because, as we talked about, that's one problem that can't be fixed in port. And one violation of that can cause you to end up on import alert. So it's really important that you double check your formulations before you send. Okay, let's see. Okay, next question. Good morning. I would like to know if it's possible to use a sticker to cover the original ingredients on my packaging. The only change is to natural ingredients. So if I understand the question correctly, let me just say that whatever sticker you use, you can use stickers to overlabel on packaging as long as the resultant product label is in compliance. So if you need to cover up an inaccurate ingredients list, then you can do that with a sticker and ship it. Just make sure that that particular sticker has an accurate ingredients list and that you have supporting documentation to support that in the event that FDA asks. Okay, let's see. Okay, sorry, whoops. Sorry, let me go back. How do I determine whether or not an imported product falls under import alerts? We are trying to import a product containing mustard, and the product got detained by FDA because of Import Alert 2604, which we were unaware of.
Let's see. Okay, so this looks like this 20, I can speak to this. 2604 looks like it is, we talked about the import alerts that are generally for product type. I think we had talked about tamarind, but it does look like 2604 is for expressed mustard oil. So for this type of alert, any shipment of expressed mustard oil, because FDA has evidence of a pattern of violations regarding when this specific type of product has arrived into the US, it will be stopped automatically. So this is an example of a green, yes, this is an example of a green list. So every time that you export that product, or any firm exports that product to the US, it will automatically be flagged and stopped under that detention, and then you'll have to get the goods released, and then that cycle will persist until you petition to FDA to be included on the green list. And you could reference the guidance section on that particular import alert to get an idea of why FDA is stopping it, and then your petition would potentially address the violative issues that FDA has evidenced history of, and you would address that in the petition to respectfully request to be added to the green list. And once you are added to the green list, if successful, then the product would no longer be flagged automatically to be stopped.
Okay, great, thank you. Okay, the next one, it's an import alert question, but I can go ahead and take this one. This question is, FDA is starting to put firms on import alert for FSVP violations. Have you worked on helping any companies with detentions for FSVP, WPE entries? Can this detained violation be brought into compliance, or is it an automatic refusal? So for those that are unaware, FSVP is the Foreign Supplier Verification Program. And U.S. importers are required to have plans to monitor their foreign suppliers for compliance. The law came out many years ago and has slowly come into fruition and is now being enforced. And because importers, many of them were either unaware or just actively not taking their responsibilities here, FDA had to create an import alert, and they're putting importers that have failed FSVP inspections on it. So my understanding is that if an importer is on the FSVP import alert, I don't believe that it's possible to bring goods in until they petition to get off that import alert. We have an entire division of food safety professionals that have assisted importers with this import alert. Generally speaking, it means developing the plan for the importer to monitor their foreign suppliers, and then having FDA review the plans. I believe a reinspection is required, and then in essence removing the importer from that particular import alert. Also, when I've looked at the import alert, it seems that if an importer has failed their FSVP inspection, where FDA found that they did not have plans in place, it lists, it seems, almost every single product category in the FDA system. So that importer is essentially blocked from importing any food products into the US. So it's a very important and a very severe import alert. So if you have importers, or of importers that are on this import alert, please do send them to us. We have a team that can help them develop plans, and then also petition so that they can be removed from this import alert. Okay. Great, let's see. Next question. Let's see. How do I know if my company is on the list of DWPE?
So those, as I mentioned, I believe much earlier in the webinar, all of the import alerts, they are publicly available. So you can go to FDA's website and you can see all of the 153 active import alerts. And then under the respective import alert, you can go to that and the specific firm, the specific address, the specific products on that import alert, and the product description, the product codes, that information is all on FDA's website, and it's under the specific applicable import alert. So it's publicly available.
Okay, thank you. Next question. We had recently a delivery under FDA review. It was released in a few days. We do not have any information what it meant that the delivery was under FDA review. Can we have more information? Is that via a NOAA? So to me, it sounds like, without seeing any documentation, that your shipment was held for FDA review. Potentially it was, it was probably physically inspected, potentially sampled, but released because no violation was found. So that's the good news. It's unfortunate that it meant a slight delay in delivery, but it seems that FDA did not find a problem with your product. So in order to get more information, the best thing to do is to contact the importer or contact the customs broker that was in charge of filing the entry. So they should have access to any notices of action that would have been issued. So likely there's a notice of action that shows that the product was being held, a notice of action that shows that the product was being inspected, and then a notice of action showing that it was released. So yeah, the good news is that it was reviewed and then nothing was found to be in violation of FDA laws and regulations. Okay. Let's see. Okay, let's see. For our next question is for Import Alert 2107. There's a green list mentioned. Could you please let me know how we can apply for inclusion of our products to that green list?
Sure, I can speak to that. So that's for tamarind, which we had mentioned early on in a webinar, and it's detention of all tamarind products because FDA has noticed a pattern of filth from many different countries. So the violative issue in question here is tamarind having an increased propensity for filth contamination. So the petition to FDA would need to address specifically what corrective and preventive actions have been put in place to mitigate and prevent the future occurrence of filth. So this could include the supporting documentation, perhaps a food safety plan. If you're doing testing, perhaps a sampling pan and the frequency that you're sampling, perhaps examples of testing reports, monitoring and sanitation records, and things of that nature. And then for this shipment, you would need to collect those cleared, detained and cleared shipments that we were speaking of. So those are the shipments that would provide evidence to FDA that the corrective actions you describe, that they're working over time. And I believe for this import alert, because it is filth, it is possible that those detentions, they may require lab testing. As they're detained, though, the compliance are responsible for the shipment. You would be provided with further information if you would need to be required to do lab testing. So those would be the two key components, and then you would compile that into the petition, and that would comprise your request to be included on that green list.
Okay, great, thank you. Next question, how long did it take for products to be released after the FDA detected violations in the case study and the timeline to correct the violations? Okay, I can take this one. So the challenge when it comes to detentions is that you end up on FDA's timeline. And FDA can take a while when it comes to getting through the process of, for example, a relabeling request to recondition. So in our examples, in that first example, we created the new labels, which, didn't take too long, maybe a week or so to create new labels. Then we submitted it, with the 766 form, but then oftentimes FDA will take a few weeks to review your petition to request permission to relabel. Sometimes the port officer will make a decision. Sometimes the port officer will send it to FDA headquarters in Maryland. So we have unfortunately seen cases where when they did this, it took 4 or 6 weeks to get an answer as to whether or not the importer was even allowed to relabel. So that's always the worst case scenario. So once you get approval, depending on the number of products to be relabeled, FDA, may grant you a few weeks. If you have 50,000 packages of product to relabel, that can take a while. So that part of the timeline depends on the number of goods to be relabeled and how quickly you think you can do it. Now, once the products are completely relabeled, then you have to notify FDA that they are ready for inspection. Again, this can vary. We've had compliance officers accept pictures of the relabeled products and just released it and said, fine, okay, looks good, great, off it goes. We've had some that will want to come and physically inspect and have taken a couple of weeks to do that. So all told, sometimes it can take a few months. We had a company that were chocolate manufacturers that had products detained in December. They were trying to get in on the Christmas season. They ended up missing not only the Christmas season, but also Valentine's Day, because it took about 3 months for this whole process. Because again, you had to wait for FDA's response. So the takeaway here really is to try and make sure you don't get detained to begin with, and to try and get all of your compliance issues settled before you start shipping, so that you never need Andrea's services. She's a lovely person, but you really don't want to have to need Andrea's services if you can avoid it. And so one of the best ways to do that is to make sure that your products are in compliance before you start shipping. Sorry, Andrea. She is a lovely person, but she's there to help people who are really in tough situations, and she does an amazing job at it.
Yes, my goal is that you do not need import alert services. And, I'll speak to that. We do have many services that can help on the front side of compliance, labeling. We talked a lot about labeling to just really mitigate and prevent these issues, because the detentions themselves can be lengthy. And then when you're speaking to a detention or an import alert that you have to collect multiple shipments, which means multiple detentions, it can take a very, very, very long time.
Okay, and so we're hitting up at our time deadline, so I'll just go ahead and find one more question, and then also, please, if we are not able to get to your questions, please do reach out to us. We have a 24-hour chat line on our website that you can use to ask questions. You're welcome to reach out to us directly as well. We also have regulatory advisors that are available to answer many of the questions that you all may have today. So let me get one more for Andrea to answer. Let's see. Okay, so since FDA are likely to take samples of the product to further analysis, how will they know the conditions required to be able to maintain the quality and safety of the product? For instance, my product requires particular temperature and relative humidity before it can be opened. Okay, I will try and answer this one. So when FDA does take samples, they, generally speaking, they should be aware of the conditions that are required. The importer, also in theory has been informed that they are going to sample the product. So again, that strong communication with your importer is very important. And so if they do take samples, the importer should be aware. They should get a notice of action that states this, and then the importer can convey that important information to FDA to make sure that they don't inadvertently determine that your products are adulterated when in fact they are not. Okay, so, and with that, we've come up on time. Again, thank you all so very much for joining us today. Please do feel free to reach out to us at the conclusion of this if we can provide any more information to you. Thank you to Andrea for all the wonderful information that you've provided today. And again, to everyone, thank you for joining us. And we hope you found the information that we presented helpful. And we are here to help you with your successful exportation or importation into the U.S. So with that, have a lovely day, everyone.